City of Wyandotte versus Corey Van, 231833.
Morning, Your Honor.
Good morning.
John Bain Jr., P37753, appearing on behalf of Mr. Van, who stands to my left. Mr. Van, please state your name for the record.
Corey Patrick Van.
All right, thank you. Change the date scheduled for sentencing in this matter on your client's plea to assault and battery. And is Mr. Vegan in the courtroom? No? Okay. All right, and counsel, did you have an opportunity to review the report and recommendation with your client?
We have no additions, corrections, or deletions. Any fines that you impose, as well as the probation oversight fees, we're going to pay in advance today. I do want to point out, Your Honor, that on the date of this incident, Mr. Van had been on the lake all day, came back to the dock, was stone cold sober when he got back to the dock. When he got back to the dock, he did have a White Claw. The victim had been drinking on the lake all day, was highly intoxicated. At one point, the victim asked for a beer. They gave him a beer. He then asked for a second beer, and they said, "You've had too much to drink." And he got mad, and he crinkled up the beer can and he threw it in the boat. My client's wife was in the boat, cancer survivor, three other adults, and Mr. Van did push him into the water. He shouldn't have touched him, but he did. We'd ask that you adopt the report. I would ask that you waive the no alcohol provision. This was not an alcohol related situation, Your Honor. It just wasn't. I mean, as to the drug provision, he's not supposed to do drugs anyway, so certainly it would be reasonable for drug testing. Anger management, you should have touched the gentleman. Anger management's appropriate. And then when we were here last, we had disclosed to Your Honor that Corey and his wife had made prearranged plans to go on a big trip to South America. I have the itinerary in my hand. They were hoping to leave on October 30th. They get back on October 11th. Yes, we'd ask that he be allowed to leave the state for purposes of going on this trip. And then as to any conditions you impose, Your Honor, he's going to do whatever you tell him to do. I've known him for 20 years, represented him on business matters. He's not a big drinker. This was not an alcohol-related incident for Mr. Van's point of view. I mean, and had he been too drunk, we tell you, Judge, he was highly intoxicated and, was alcohol-related, but this one wasn't.
Okay, and I hear what you're saying, counsel, which quite frankly, so your client makes your client's actions even more incredulous. So your client is stone cold sober. There's somebody that is intoxicated and he pushes them into the water. Then the individual is trying to get back up on the dock and your client pushes them back in the water.
That actually let go of his hands, but yes, Your Honor, I'm not.
And with the fact that this individual was intoxicated, and as you're indicating, severely intoxicated, to push him into the water, your client's lucky he's not looking at homicide charges. I mean, it's very fortunate that the individual didn't drown.
I understand, Your Honor. Last time and this time, we completely acknowledged that Mr. Van should not have touched this gentleman. So I'm not trying to minimize the fact that he touched him.
Your Honor, may I ask you?
Okay.
I was trying to help him out of the water, and the reason I let go of his hand was because he was threatening me and telling me he was gonna kick my ass, and I let his hand go. He went back in the water.
Well, sir, you just pushed him in the water. You don't think he's going to be upset? Whether or not he's sober or not, you don't think he's going to be upset?
Yes,
And then, given the fact that he's intoxicated and probably has less of a filter, given the fact that you just pushed him in the water. So you're trying to help him out apparently, and you didn't like what he said, so you let him back in the water. You just dropped him back in the water, pushed him back in the water. However, he ended up back in the water. All because apparently an empty crushed beer can was thrown in your direction.
yes, ma'am.
And some of which were called.
I'm sorry?
It was more than just a beer can, but we acknowledge that he shouldn't have touched it, Your Honor. He was belligerent, profane, I mean.
Did you know this individual?
I met him occasionally. He is the people that are in the slip next to us that we were out with all day. It's the owner of that boat's daughter's boyfriend. I've met him, I believe, 3 other occasions, and there was the time before, the last time I had an encounter with him, it was the same thing.
Well, it wasn't the same thing.
Well, no,
You didn't touch him.
I didn't touch him that time, but he was threatening me. Telling me he's gonna kick my ass, and I don't know, I just, his father works in the same industry that I do, and so he has a little bit of a knowledge with the industry, and just was being obnoxious, telling me I don't know what I'm doing, and it's,
So when you have somebody like that, sir, just ignore them. When they're drifting, ignore them even more.
We agree, Your Honor.
The court, after hearing from counsel and hearing from Mr. Van, reviewing the report, the recommendation, the court does find there's reasonable grounds to depart from MCL 769.5. The court's going to indicate 12 months probation. You are eligible for early discharge with a hearing. The court will note that you are also eligible under 771.1 status. Not to violate any criminal law of any unit of government. You're not to leave the state without the consent of this court. The court will note that you do have this trip planned. And apparently you booked it on September 5th before you even came to court the first time. Ma'am, whether it's booked or not, there's an email from September 5th and you're not identified for the record. So,
What did you say? Just tell us.
well, the point is it was booked prior to the
Yes,
first court
yes,
date.
yes.
I'm just trying to make a record that that's when it was booked prior to that.
it's been, the planning started over a year ago.
All right, the court will grant you permission to travel for that. Sir, if you behave like that in South America, you probably won't be coming back. So hopefully you have it together that you're not behaving in that manner
Yes, ma'am.
or that fashion. If somebody's belligerent, let them be belligerent and walk away. Mr. Munasar, please hit join. The court will note as well you to report truthfully to your probation officer. The office of your probation officer may require in person, writing, or virtually. You're notified probation officer immediately if any change in address or employment status. The court's going to order no alcohol or drug use unless prescribed to be subjected to random testing. We can revisit that, council, at some point, but for now, that's what the court's going to indicate. The rehabilitative goal for that condition is to monitor your progress in maintaining abstinence and sobriety. I understand that you were sober for this event, sir, but if that's how you behave when you're sober, I would be more concerned with you're not. You're to participate in the. I'm not going to order the chemical awareness program. I'm not going to order the chemical awareness program. I am going to order you to participate in an anger management program. I don't believe one day is sufficient, especially given the fact that you have a prior malicious destruction of property that tells me that you still have some issues with how to handle upsetting situations. So the court's going to indicate 8-week anger management program. The rehabilitative goal for that condition is to assist you in expressing your feelings and needs in an appropriate fashion and to prepare you for upsetting situations. Not to have any contact with Kyle Vegan, and there's no restitution requested at this point. If there is restitution requested later, it has to be in the form of restitution hearing. Okay? Any questions regarding the terms and conditions?
No, ma'am.
All right. And as to the fines and costs, the court will indicate a $400 fine, $100 screening assessment fee, supervision oversight fee of $600. It's 12 months at $50 a month. Since you're eligible for early discharge with the hearing, so up to $300 of that may not be due. $200 for cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50 for a total of $1,325. And counsel, I think that you said that your client had money to pay today. I don't know if you indicated an amount. Did you indicate that your client has money to pay today or no?
Yeah, he'll be paying today everything.
Okay, so let's hold off on 300, so keep that back. So it'd be $1,025 today. All right, sir, when you're done here, you're going to have a seat over probation. Somebody will be with you shortly to address the terms and conditions. The court's going to also indicate, as I did, that you're eligible for early discharge with the hearing. You can request early discharge if you've completed all of your terms and conditions. You've had at least 3 months without any violations. All monies have been either paid in full or you've made a good faith effort toward making full payment. Okay? Thank you. Have a good day. Somebody will be with you in just a few moments. All right, I take a brief recess.